We usually think of international law as this big collection of treaties and customs that have been around forever. But what happens when those rules just run out? When there's no treaty, no custom, nothing? Well, today, we're cracking open the hidden toolkit that international judges use to solve exactly that problem. Let's dive in.
Okay, so put yourself in the shoes of a judge at the International Court of Justice. This massive, complex dispute lands on your desk. You go looking for the answer in a treaty, you search for a clear custom, and you find zip. The law is totally silent. Now, in a national court, you'd probably have piles of previous cases to look at. But international law, it's a much younger, less developed system. So what on earth do you do?
Believe it or not, this exact problem has a name. It's called non-liquid, and it is a judge's absolute nightmare. It's that terrifying moment where a court might have to admit it can't make a ruling because there's just a gap in the law. And for the international legal system to have any real authority, it can't just throw its hands up and say, sorry, we don't know. There has to be a way to make sure every single dispute can be settled.
Luckily, the people who designed the modern international legal system saw this problem coming a mile away. So what did they do? Well, they built a kind of safety valve, a backup plan, right into the court's DNA to prevent everything from grinding to a halt.
And this safety valve, this is what gives judges a really incredible power, the authority to find the unwritten rules. Yeah, these are the basic, fundamental ideas of justice that the whole system is built on. And the best part, they're hidden in plain sight, right inside the court's own rulebook.
And here it is, Article 38 of the ICJ statute. This is basically the menu of options for judges. Right after treaties and custom, you find this little phrase, this is the gap filler. It's the tool specifically designed to solve the non-liquid problem once and for all.
So, what does that legalese actually mean in the real world? It means international judges are allowed to look at all the different legal systems on the planet. Common law, civil law, you name it, and find the core ideas of justice that they all share. It's like they're searching for the common legal DNA of humanity.
Now, of course, lawyers and philosophers have argued for centuries about where these principles even come from. Is it like the natural law folks say that these are just universal truths about justice that exist out there in the universe? Or is it what the positivists argue, that they only count because states have in some way agreed to them? It's a fascinating debate, but for us, the most important thing is courts actually use them to decide real cases.
So, how do they do it? Let's get practical. One of the most common ways is for international courts to borrow ideas that are already tried and true in domestic legal systems, what lawyers call municipal law.
The thinking here is pretty simple, right? If a legal principle shows up again and again in all the major legal traditions across the globe, it's probably a pretty solid, fair, and necessary idea. So it's a safe bet to apply it on the international level. Let me show you what I mean with a couple of real-world examples.
Our first case comes from a pretty unexpected place, a fight inside the United Nations itself. The whole thing boiled down to one question. Once a court makes a decision, is it final? Like really final, even for the UN. And at the core of this dispute is a principle every first-year law student learns, res judicata. It's a fancy Latin term, but all it means is that once a case is decided, it's over. You can't just keep suing someone for the same thing again and again. Simply put, no do-overs.
So back in 1954, some UN employees got fired. They took their case to a UN tribunal, and they actually won. But then the UN General Assembly itself started asking, wait a minute, do we really have to pay them? So the International Court of Justice weighed in, and its answer was a hard yes. The court said the general principle of res judicata applied. The tribunal's decision was final, and it was binding on everyone, including the General Assembly.
All right, let's look at another one. This is such a great story. It's all about an ancient temple right on the border between Cambodia and Thailand.
And the legal principle here is called estoppel. Again, it sounds complicated, but the idea is simple. You can't act one way for decades, letting everyone believe that's your position, and then suddenly flip-flop when it's convenient for you. You are estopped, or blocked, from going back on your own past behavior.
So get this, for 50 years, Thailand had been using a map that clearly showed the Preah Vihar temple was on the Cambodian side, and their actions totally confirmed this. At one point, in 1930, a Thai prince even visited the temple and was officially welcomed as a foreign guest, with the French flag flying overhead. The court looked at all this and said, look, your behavior over all these years shows that you accepted the border. Thailand couldn't just wake up decades later and say the map was wrong. They were estopped.
Okay, so we've seen how judges can borrow from national laws, but sometimes they identify principles that are even bigger than that. Ideas that seem to be part of the very fabric of law and justice itself, no matter where you are.
Yeah, these aren't just about legal procedures, these are about the core meaning of justice. They're about what it even means to have a legal duty to begin with. I mean, just listen to this quote from the famous Chorzów factory case all the way back in 1928. The court said it's a general conception of law that if you break a promise, you have to fix the damage. It's the most basic rule of accountability there is. You break it, you fix it. And maybe the most important principle of them all is good faith. As the ICJ said in the nuclear test cases, trust and confidence are at the heart of international cooperation. The whole system, every treaty, every agreement, is built on the simple assumption that countries will act honestly. Without good faith, the whole thing just falls apart. So we've gone through some pretty powerful examples. Now let's just zoom out for a second and think about why these unwritten rules are so incredibly important for the entire world. This table really sums up that hidden toolkit, doesn't it? You've got reparation. You break it, you fix it. You've got legal finality with res judicata, no do-overs. And you've got basic fairness with estoppel and good faith. When you put them all together, these principles create a really strong foundation for global justice.
So, why does all this matter? Well, first, these principles make sure the law is complete, so the whole system doesn't just crash when it hits a new problem. They give the law flexibility to grow and adapt. And maybe most importantly, they reinforce the rule of law itself by making sure a court can always deliver a decision based on principles of justice that are shared all over the world.
And that kind of leaves us with one last big question. International law isn't stuck in the past. As we face these massive new challenges, things like AI, cyber warfare, climate change, stuff that the writers of the UN Charter couldn't have even dreamed of, the need for courts to find these fundamental principles is only going to get bigger. The real question is, what unwritten rules will they need to find next?